Our apologies for being late into court. If you need the extra 10 minutes, you may have it.
My lady, my friend has just handed me at 10 to 2 an 18-page written document setting out further argument, and I object to it being received by the court. Both sides have had the opportunity to put in written cases and written responses. In fact, my learned friend's first written case...
Mr. Palmer, we receive speaking notes all the time.
Well, I'm not sure how
as long as it's a speaking note.
Well, as my friend has indicated that he won't be speaking to it because he'll run out of time, and therefore he's asking you to take into account arguments which will not be orally supported, and therefore I can't deal with it orally because I won't hear it. That's my problem.
It's designed to speed up the process, my lady, and enable me to get through it all in the short time that we have.
We will do what we see fit with it and what we hope will be fair with it.
Thank you, lady. Next question is, does the court have it? It's got... yes, that's it, my lady. Thank you. My lady, can I just indicate that we'd got part way into it before lunch, so I can take you straight to the bottom of page 2 of that. I had... Yes, I think you got the points, I won't repeat them. What I wanted to make as a third point was, if you looked at the Advocate General's opinion in the Handelswerkerei case, you will see essential differences between EU and non-EU jurisdiction rules for claims in tort. And there are 5 points really that emerge from it, if you're kind enough to go over.
So would you give us the reference to that?
Handelswerkerei is in volume 9, tab 95, and it starts at 3358, my lord.
It starts at
3358, my lord.
Right.
Do you want us to look at it?
Yes, I'm hoping that the citations over the page will help me get through it much more quickly.
Thank you.
But there it is.
Sorry, where you referred to 5 points you extracted from the Advocate General's opinion.
Yes. If
and
you
where
go
do we
to
find
3361, my lord.
You give them the references. 3358. 3358 start.
Starts and 3361 is. On the other hand, so it's just below C. On the other hand, differences existing between national legal systems with regard to substantive rules on non-contractual law cannot be considered as ruling out independent definition of the concept employed in Article 5.3. Must not be forgotten that in the above-mentioned judgment, the court had indeed emphasised the independent nature of the interpretation of the concepts contained within the Convention. It may be further added that an independent definition, where possible, of the words employed by the Convention for the purposes of defining the jurisdiction of the court undoubtedly helps to promote the recognition and enforcement of judgments of the court in the contracting states. So there's the underlying reason for it.
What that is saying, surely, is that that these concepts have an autonomous meaning in EU law.
Yes.
But that doesn't meet the point that the English jurisdiction rules were deliberately amended so as to conform with that authoritative meaning. It may or may not have been achieved, but that was the object, was to conform with the autonomous meaning given to them in EU law. That's why the 1987 statutory instrument was expressed to come into force when the Civil Jurisdiction and Judgments Act brought the Brussels Convention into force in the UK, and it is why that view of its purpose is expressed both in Dicey and Morris and by the Court of Appeal in the RS Isle litigation.
Yes, I have to come on and I deal with that later on in this submission. But there wasn't a complete assimilation, there wasn't a complete alignment between the two. It did not do away with the forum conveniens requirement that there was within this jurisdiction, and therefore there wasn't an attempt to ensure that the same wording was transposed into the RSC. It wasn't, and it never has been since.
Well, the forum conveniens jurisdiction as applied to cases within the Brussels and Lugano Convention has been disposed of by other decisions of the...
Yes, no, I accept that, Lord, but we're talking in this case about cases which are happening out with the EU jurisdiction. That's all I'm concerned with. And what I'm endeavouring to establish here is that he was recognising that there were various formulae which could be adopted. I haven't yet got to that point there. That could be adopted where... And the ultimate decision, I think you can see, is arrived at by virtue of the fact that he's saying at the bottom of 3366, for example, having thus discarded the theory of the most significant connection, we should accept that cumulative solution, which would leave the plaintiff free to choose between the court of the place where the act was committed and the court of the place where the event occurred, may appear by its very liberality fairer and better able to accommodate the characteristics of the various types of unlawful act. Indeed, we have seen that within the national systems, this solution has now been broadly adopted. Despite this, it does not appear to me to be in accord with the letter and spirit of the Convention, and is at odds with the spirit of the Convention. It is at odds with the letter of the Convention because Article 5.3 refers to the court of the place where the harmful event occurred, and that is to a single court and to a single place. So he's reviewing a variety of options that could have been available, but ultimately deciding that the particular wording of Article 5.3, which we did not adopt, has the critical words, the court of the place where the harmful event occurred, hence the link to direct damage, which we've never had. And so that's the point that we're endeavouring to make on page 3. The first point being the place where the harmful event occurred, taken from French and German law, the place where the harmful event occurred have an independent autonomous meaning in EU. They do not depend on domestic law for their meaning. It was not the intention of the draftsman to define the words place where the harmful event occurred. Instead, their meaning was to be left to untrammeled developments in the case law, 3362.
Do you accept that it has, the place where the harmful event occurred has always, in the CJEU jurisprudence, been treated as being the place where the damage was suffered?
It wasn't at the time this introduction to the RSC occurred. It was, and this case is further confirmation of it, and indeed, Mr. Justice Tugendhat deals directly with this point in the case of Cooley, paragraph 37, which is at bundle 3, tab 24, and it's dealt with at 1359.
This one you've just taken us from beer.
Yes.
Is the chemicals down the Rhine.
Yes.
And never mind the Advocate General for a moment.
Yeah.
What was the decision of the court? Was it that the place where the harmful event occurred was both?
Both. It was both.
The place where the stuff went in and the place where it ended up
Correct.
causing harm.
It was both. Right. So I was saying it was dealt with by Mr. Justice Tugendhat. 24.
Paragraph 24.
No, sorry, tab 24 in volume 3, paragraph 37. It's 35, in fact. It goes to Marinari at 37. But Mr. Palmer starts his submissions with the case of Metal and ABCI and Handelswerk Karai. But Parliament did not fully assimilate the rules relating to non-party states with those relating to states which are parties. The significant difference that Parliament left in being was that under the Convention and the Judgments Regulation, the Court retains no discretion, whereas in relation to non-party states, there is the discretion to be found in the CPR. It follows from this, in the words of Professor Briggs in his book, 4th edition, as it then was, there's no compelling reason to apply this line of convention, and probably a regulation authority outside the field of application of the convention or regulation itself. That is so is apparent from the case of Marinari.
Well, we have a very similar situation under the Hague Child Abduction Convention, where it's partially governed by an EU regulation, which we obviously have to apply as between member states.
Yes.
But as between states parties to the Hague Convention, if they're not other EU member states, we're governed by what the English Act of Parliament says, the UK Act of Parliament says. Now, we do sometimes say, yes, but it says that in Brussels too, so we'd better do that for all of them. But we don't have to.
No, quite. And that's the case here.
It's a similar sort of situation you're arguing. Yeah.
I think that may be right, lady, yes. And as we'll see when we come and look at the first instance decisions, this issue of EU law and what effect it should have upon our jurisprudence on service out of the jurisdiction is addressed head on. So I'd got to page 3D and dealing with this very point. So despite the attractions of a more liberal approach, which he thought might be fairer to claimants, it's the court of the place that proved to be, in his view, a determining factor. Over the page at E, the Advocate General is also stating Article 5.3 is an exception. That's why you have regard to it and a specific definition. It's an exception to the general criterion for jurisdiction based on the defendant's domicile, and accordingly is not to be widely construed unless this is directed by the words of the convention, and there's no such constraint or limitation that exists in CPR.
Now, in beer, the damage was sustained, was it, in one country only? Well, that's the damage that was in issue in the proceedings was, whether anybody else suffered elsewhere is a different question, but the damage in question had all been suffered in Holland, hadn't it?
Thank you, Lordships. So,
somebody will let us know if it wasn't, or else we'll read the case fully ourselves.
It is correct, yes, it is correct.
So the fourth point we were going to make on page 4 is, if you compare the wording of the CPR with the Brussels regulation, you can see how different the wording is. So on the one hand, you've got damage sustained within the jurisdiction, our wording, a Brussels 1 regulation in the courts for the place where the harmful event occurred or may occur. That wording being so different, we submit it would be odd if this court were to construe them as saying the same thing. The next point on the same page is that it was obviously open to the Supreme Court Rules Committee in 1983 when we changed our RSC wording to amend it so that it coalesced, and they did not. They've had ample opportunities since to amend it so that it would coalesce or coincide, and they have not done so.
What did the Gennard report say about the effect of 5.3?
I think if we look at the bottom of 3361, there's a reference there to it. In the rapport Gennard, it was stated in this connection, the committee did not consider it appropriate to specify expressly whether account should be taken of the place in which the act causing the damage was effected, or on the other hand, the place in which the damage had occurred. Instead, the committee considered it preferable to employ wording adopted by various national legal systems, Germany and France. And then I suppose you can go down to C on page 3362. The draft leaves open the question of the place of the one or other country must be understood, and he maintains the purpose of this was to leave untrammeled current developments in case law. And that's what we did. Now, the court will be alive to the fact it's not in your bundles, but in the Civil Procedure Act 1997 is the act which empowers the Rules Committee to amend the rules. And you can see that from the documentation that is within the bundle. We have copies here if the court would be assisted by it. In the statutory instruments, which you do have in your bundles, at 986, volume 986, which is the statutory instrument of 2000, and 987 for the statutory instrument of 2008. And it specifically cites this empowering provision within the Civil Procedure Act 1997, which empowers it to amend the rules. Right, over the page 5, the point here is that the jurisprudence of the Court of Justice as to the meaning of the place where the harmful event occurred or may occur has evolved over time. So that shows, so we refer to Handel's Quackverei there, decided in the late 1970s, so this is some years before the RSC rule change. It did not deal decisively with indirect or consequential damage and where this has been sustained for the purposes of an EU case. It's not until Dumez in 1990 and Marinari in 1996, or 1995, it was probably decided then, that the European Court resolved this indirect or direct financial loss and ruled that indirect financial loss did not suffice to found jurisdiction under Article 5.3. And as the court knows, there's been a similar evolution of our RSC provisions, moving into the CPR provisions. All those evolutions have occurred, not necessarily at the same time, but they've occurred in parallel with the developments in the case law that have occurred in Europe. And as the court knows, even after this case, the European and non-EU approaches remain unaligned with respect to Fatal Accidents Acts, because there you've got Brownlie on the one hand and Lazar on the other, Lazar being an EU case. So the point we make is why therefore choose a date in 1990 when Dumez was decided rather than an earlier date by which to determine the question of our domestic common law procedure and how it should proceed and how it should define what it regards as sufficient damage to warrant assuming jurisdiction over a particular case. So, seventh point, at the bottom of page 5, the issue of sufficient connection is of fundamental relevance to the forum conveniens requirement, and you can see this in Professor Briggs's article, which I will, with respect, take the court to. So that's in volume 10, tab 108. Passage I invite the court to in this regard is 3527. But could I say in passing, we've moved on from the test for what proof is required, and invite the court's attention to the whole of this article. It is very detailed, and it deals with a good arguable case as well. That starts at 3522. I just mentioned that for your Lordship's notes and your Ladyship's note. So it starts here, and he's drawing a distinction between the regulation requirement for damage occurred within the jurisdiction of the court, and he's saying that the test for common law is some damage was sustained in the jurisdiction. And he sets out the counter argument, the European position on 3528. So could I take the court to 3529, please? And he's dealing with, at the very top of that page, nature or meaning damage sustained within the jurisdiction. It's submitted that this should mean something undemanding. In Metal, the Court of Appeal read it to mean that some damage, but not all of it, had to be sustained within the jurisdiction. He goes on to deal with the case of Booth, which I shall take your Lordships to shortly. And if, as Lord Sumption observed, although the point has not been judicially made at the time, the most important question was whether England was the proper place to bring the claim. There is no need to strain one's muscles over the issue of where the damage was sustained. Of course, if the sustaining of some consequential damage were to form the only link to England, it would not be surprising if England were not the proper place to bring the claim. But this would be an observation and not the application of the rule. Although this interpretation may have caused initial surprise, it is now evident that judicial instinct had been right all along. It therefore came as a surprise when the Court of Appeal all but overruled these first instance decisions. And then he goes on and deals with matters thereafter. He also deals with it, if you could, in the same volume, go to tab 110, please. This is his book, the 6th edition, paragraph 4.73, which appears on MS page number 3547. Over the page. So 3547, he's dealing with the case of Metal, which we've been to. Over the page, he's dealing with Booth. So, for example, medical expenses incurred in England or the loss of earnings which would otherwise have been gained in England will satisfy the requirement of damage sustained within the jurisdiction, even though this may be the consequence of damage which was done more immediately elsewhere. The second point is that pure financial loss may be more difficult to pin down to a specific location, but that it is probably unnecessary to take too technical a view of the point for the reason which follows. It's certainly true the immediate predecessors of subparagraph 9 were said to be drafted to bring the tort head of jurisdiction into line with the special jurisdictional rule which now appears as Article 7.2, Brussels 1, and has been elucidated in Handel's Kwekerij. This approach was initially supported, but there was no credible reason to apply this line of Brussels authority outside the regulation itself. The function of Article 7.2 as an exception to the general rule of Article 4, and as a rule of special jurisdiction not further controlled in its application by the principle of forum convenience, is quite separate and has functioned quite different from subparagraph 9a. For where jurisdiction is to be asserted under that rule, the claimant must also separately, clearly and distinctly satisfy the requirement of forum convenience before the court will authorize service to be made out of the jurisdiction. There is therefore no need for alignment with a jurisdictional rule which serves a quite different function. Where the damage is physical, it should not be problematic to show where it was sustained. Where it is economic, however, there is more scope for differences of opinion and analysis, but the court has a discretion to allow service out in any event. There's no compelling need to be restrictive about what is needed to satisfy this element of subparagraph 9a. And he gives examples thereafter, which the court no doubt will find helpful. The gist of the complaint is the money being received in England. Then it is another example, the victim of a tort such as misrepresentation in the next paragraph. And he ends just above 4.74. In the result, the correct approach is, in practice, not to be too clever or analytical when it comes to the location of intangible or financial losses, but to rely on the principle of forum convenience to screen out those cases in which the damage connection with England is too weak or tenuous to justify service out. Now, I've got a note here also that if one looks at paragraph 13 of the minutes of our Rules Committee, which will be at tab 128 in the same bundle, at 3700, so this is a proposed new Gateway 5 by the Rules Committee, Lord Mance in charge. This is the closely connected fact, so this is a change that's been brought about in the rules since this case. So, 13, in principle, we agree with the Mance Committee that this is a worthwhile proposal which should be supported.
Sorry, where are you reading from?
3700, 3700, paragraph 13.
Right.
These are the minutes of the Rules Committee.
This is the minutes of the Rules Committee, correct, lady? So if we come to the last sentence of that paragraph, it is worth emphasising at this point that, as with all the gateways, before deciding to grant permission to serve out, the court needs to be satisfied as the appropriate forum for resolution of the claim, and that it is appropriate to exercise the court's jurisdiction in favour of granting permission. So it's a strong support of the judges of the commercial court.
That's a piggyback claim, effectively, isn't it?
Yeah, yes. So if we'd got through one gateway in contract, the tort being on the same or similar facts, we would be allowed to bring our tort claim as well without having to satisfy a separate route through a tort gateway. And vice versa. So, point 8 on page 6. The defendant's point is there set out. We submit this misses the point. The key thing about the EU is that it seeks harmonisation as to the jurisdictional and applicable law rules. Why? Because it has an aim. The aim is clear: legal certainty and predictability of outcome. And the factor that influences all that is the mutual trust between the courts of member states when they're operating the EU regulations. We're submitting at the bottom of that page, in other words, there's something fundamentally different about the position within the EU where mutuality and reciprocity justify legal certainty and predictability of outcome, and the position outside the European Union where there is no such multilateral framework and therefore a need for a more nuanced and discretionary approach. Then the defendant is making a submission that we're quite wrong to suggest the recent changes to the wording of the Tort Gateway Supporto case. Our response to that is, well, the defendant may be right that the wording was altered to reflect the changes to jurisdictional rules on quiet time at injunctions, but it does not appear to have anything to do with Brussels legislation. The gulf between the regimes remains. The wording of the directive and the CPR remains wholly different, and the structure of the regime remains wholly different. Again, we compare and contrast it at the bottom of that page. The EU rule in Article 7.2 of Brussels 1, matters relating to tort, delict or quasi-delict in the courts for the place where the harmful event occurred or may occur, no forum convenience to be added. Our common law, non-EU rule in the CPR, claim is made in tort where A, damage was sustained, or will be sustained within the jurisdiction, plus a need for a reasonable prospect of success, plus a need to satisfy the forum convenience discretion. The wording remains wholly different. The structure and the regime remains wholly different. So then we come to the authorities on the gateway and what damage was sustained within the jurisdiction might mean. We set out the three options as we perceived them on page 8. Does it mean that all of the relevant damage has to be sustained within the jurisdiction, which would give rise to obvious practical difficulties in an economic tort case, where financial losses might be scattered across several jurisdictions? This is a point which Professor Briggs made in the article that I have just taken the court to. Secondly, does it mean that only direct damage will do, which in itself begs the question, what is direct damage caused by the relevant unlawful act? Thirdly, does it also embrace indirect or consequential financial losses, as the first instance decisions say that it does?
Does the concept of the location of damage mean the same thing in the jurisdiction rules, the gateway, as it does in Rome 2, where almost identical form of words is used?
The applicable law.
Yes.
Matter. Yes. Well, can I say by way of a quick answer to that, Lord, this issue is addressed directly by the then Sir Robert Nelson in the case of Stiliano, which is one of the cases I'm bringing you to. And he addresses the EU regulations in considerable detail in his judgment. Says, in short, that they don't assist in the interpretation of our CPR provisions. I've already taken your lordship to our footnote 16 on this, which is Professor Briggs's examples and his suggested solution, which is not to be over-analytical, to use forum convenience to screen out cases with an insufficiently strong connection with England. Now, the next question advanced by the defendants, is it desirable or appropriate objective to treat personal injury and fatal accident tort claims differently from non-contractual claims on the basis that injury and death should be treated as the damage for the purposes of our jurisdiction? Now, we start by saying, well, it rests on a questionable premise, because we can cite a number of cases where this will cause very real difficulties, quite apart from some of the examples that are represented by the first instance decisions, which we're going to come to shortly. First of all, you cite the case of mesothelioma. The chances are, given the long gestation period between the injury inflicted on the individual when damage first occurred to him, and when he first could conceivably become aware that he'd had this disease, he may be living in a different country altogether by that stage. He may have worked abroad and suffered it there, but normally lives in the UK. What's to happen to that scenario? Similarly, I cite another example which would occur quite regularly. One of our servicemen serving abroad suffers an injury in a foreign country, serving the country. His PTSD very often is delayed. It's manifested only when he comes back to this country. Is he to be required to sue in Iraq, for example? And there are also the misrepresentation tort cited by Professor Briggs. So, over the page, we attempt to provide some answers to these. Firstly, the European Court's been able to use a narrow wording of Article 5.3 and the principles of interpretation of EU legislation to resolve these matters, but these tools do not assist with respect to ours. Your Lordship, the court knows, Milady knows, that the primary foundation for jurisdiction in the EU is domicile. So there's always that starting point. This 5.3 provision is an exception to that basic rule. That's why they can afford to confine it in the way that they've decided that they wish to confine it after 20 years or so of jurisprudential consideration. Difference between Beer and the Dunes and later decisions. Secondly, we submit there's no clear or bright line that can always be drawn between direct and indirect losses. That definition is very elusive. Thirdly, in Metal, the court adopted the pragmatic solution to the question of whether all the damage suffered had to be sustained within the jurisdiction, and it decided that it did not. It was sufficient if significant damage had been sustained within this jurisdiction. Fourth point, there's no justification for treating personal injury and tort claims differently from other species of tort claims. Such differentiation finds no support in the wording of the CPR or indeed any later case law. Fifth point we make, if a pragmatic solution is adopted, namely that there was some indirect consequential loss sustained in England, and there is a sufficient connection with England, then all these conceptual difficulties fall away. What we say next about the authorities, which I'll take your lordships to the court to very shortly, is the English authorities are pretty well established now, and they deal specifically with Personal Injury Act claims, Fatal Accidents Act claims, and they provide a pragmatic solution of the type that we're urging. And all these authorities confronted head-on the issues raised by the present appeal and cross-appeals and have been dealt with comprehensively in the parties' arguments, which are addressed in those cases. Indeed, my learned friends for the other side appear on both sides in these cases down below. So, if we go to those English authorities very briefly, can I take the court, first of all, Volume 2, Tab 14, which is the case of Booth. This is a Fatal Accidents Act claim, the first thing the court should know. He who is now Mr. Justice Tier presided, he found, I'll just summarise it for the court if I may, some damage.
Can I have a page reference, please?
Yes, sorry, 1003, my lady.
Thank you very much.
Some damage suffered within the jurisdiction was sufficient. What he was not looking for was damage which completed the cause of action. Damage is to have its ordinary and natural meaning of harm, which had been sustained by the claimant, whether physical or economic, and financial detriment resulting from the claimant's loss of dependency on her husband and expenses of his funeral amounted to damage within the meaning of the CPR. His analysis is at paragraphs 32 to 34. 1009, my lady. And he gives effectively seven reasons, which are set out in paragraph 35. I think it'd be quicker if I invited the...
Would you like us to read 35?
Please, thank you. And you'll notice at paragraph 38 a passing reference to Natal as well.
I think we're all there, Mr. Frost.
Thank you. If we go to Cooley and Ramsey, which is at volume 3, tab 24, decision of Mr. Justice Tugendhat, my learned friends, both of them appearing for the defendant in that case. Facts.
You're going to give me a page reference?
I will, sorry, forgive me. Page reference is 1351, my lady.
Thank you.
Mr. Justice Tugendhat, facts, an accident in Australia, very severely handicapped. He's repatriated to England from whence he originated to receive care for the rest of his life. Decision in a nutshell, decision in Booth was correct. Mr. Justice Tugendhat holds he's not obliged to follow Marinari. Paragraphs 17 and 18 are the passages which I'd invite the court to look at in the way of a challenge. And 35 to 53 are the reasons. This is where he makes the point there hasn't been a full assimilation. Parliament did not require a full assimilation with the EU rules. And he sets out effectively 10 points, which stretch across to paragraph 51.
I'm sure you don't want us to read every single one of those paragraphs now.
No.
Merely note that that's
Thank you, I'm obliged.
what he does.
The next case, could I just, rather than take the court to, could I just invite a note to be taken? It's the case of Harty and Sabre International. It's in volume 4, tab 40, and at MS page 1794, lady. Decision of Mr. Justice Macduff. It's right to say that this issue of consequential damage point was conceded by the defendants in that case. But the facts are familiar. The claimant sustains significant injuries in Iraq. He's returned to England to convalesce. Basically, there was immunity from suit for the defendant employers whilst he was working in Iraq. And the court obviously makes the point on the defendant's approach, despite the lack of access to justice in Iraq, where there was, as I said, immunity from suit, the claimant would have had no entitlement to sue in England. Again, Saldana is the next case. I don't take the court to that, just the citation is at volume 6, tab 63, MS page 2470. Booth and Cooley are cited. In this case, the claimant is injured on a ship anchored in English waters. A conclusion is at paragraph 16 to 17, hospitalization within the jurisdiction sufficed, according to that decision. There is then a comprehensive analysis in the decision of Mr. Justice Haddon Cave in the case of Wink, where my learned friend Liz Kinsler appeared for the claimant. That is to be found at volume 8, tab 78, MS 2955. Here, the claimant is seriously injured whilst on holiday in Croatia. Claimant's repatriated to the United Kingdom following surgery and spends a number of weeks in hospital. And then there's an application to set aside service. In short, Booth and Cooley are applied by Mr. Justice Haddon Cave. The submissions for the claimant are set out at paragraph 19. The submissions for the defendants, paragraph 23, with detailed reasons at paragraph 31. These are the ones which are being repeated to this court today. The analysis by the learned judge starts at paragraph 32, goes through to 42, MS numbers 2960 to 2962, my lady. The learned judge gives effectively 9 reasons. I'll summarize them, given an hour. 1, the fact that the tort may be complete on proof of loss and damage does not mean jurisdiction cannot be founded by proof that some of that loss or damage occurred within the jurisdiction. Secondly, damage can be suffered in 2 jurisdictions. Thirdly, damage amounts to some damage. The word damage suffices for some damage and does not require any additional words being added to it. 4, the rules were intended to be simple and simply expressed. 5, the Mattel decision of the Court of Appeal supports this conclusion. 6, indirect damage is not too uncertain given the forum's convenience requirement. 7, a wide construction does not offend the rule against exorbitant jurisdiction, particularly in the light of the decision of this court in Abella. 8, Article 5.3 of Brussels 1 is not relevant to construction of CPR. 9, pain and suffering and loss of earnings continue to be suffered within the jurisdiction. I invite the court's attention to that decision as it is well reasoned in our respectful submission. As is the next case, Stiliano, which is in volume 7 at tab 71. MS 2720. Sir Robert Nelson. Facts again rather familiar. Now, claimant a passenger in a car accident in Western Australia. She's an English resident on holiday there. She's in hospital there for full 3 months. She's then repatriated to Stoke Mandeville Hospital for all the obvious reasons. Paragraph 10 might be a good place to start, which is on MS page 2723. Deals with the actual wording of CPR, effect of the decisions in Booth and Phillips and Cooley. Terms of Rome 2, when read as they must with CPR 6, require a narrow interpretation of damage sustained within the jurisdiction, limiting its meaning to direct damage. That's a submission by the defendant. And he turns to consider Brussels 1 and Rome 2 in the ensuing paragraphs. We can go on to paragraph 43, where he deals with the effect of those on the interpretation of CPR. He refers to Mr. Justice Tugendhat's reasoning in Cooley. to Professor Briggs's views on Booth and Cooley. Mr. Justice Haddon Cave's decision in Wink, paragraph 45, and he considers all those are correct. Then deals with Rome 1 and Rome 2, and says in paragraph 47, halfway down, this does not, however, in my judgment, mean the rules of jurisdiction under Brussels 1 are to be overridden by the provisions of Rome 2. Brussels 1 relates to a different subject matter, namely jurisdiction, has to be considered as a separate regulation. Rome 2 does not abolish the discretion which was exercised under CPR in relation to non-member states. Mr. Bloch's submission, paragraph 48, the answer at 49, there is, in my view, a difficulty with this argument. Article 2 states that damage for the purposes of Rome 2 shall cover any consequence arising out of the tort or delict. This on its face is wide enough to include any damage, direct or indirect, which the regulation as a whole covers. Towards the end of that paragraph, I see no reason why damage under CPR should be interpreted as in a specific article under Rome 2, such as Article 4, which defines the applicable law, rather than interpret it as a general article, such as Article 2, which applies the regulation as a whole, apart from 4. And then paragraph 53, he deals with the submissions that he accepts. Case of Pike, I'm going to just mention that, given the time. I've only got 10 minutes of my time left. Case of Pike, it's at volume 6, tab 58, MS 2280, decision of Mr. Justice Stewart. This is a victim of the terrorist attack at the Taj Mahal Palace Hotel in Mumbai in 2008. Given the attack, he's one of the British guests there. He tries to escape from his room. He falls from upper floors. He suffers severe spinal injuries, and he's rendered paraplegic. The evidence placed before the court establishes there would be no access to justice before the Indian courts, but for a 15-year delay, unless he was prepared to wait that long, held, not surprisingly, a case of great hardship, no real access to justice in India. He finds that this is the appropriate place to deal with the case, and the injuries, although sustained directly in India, obviously are felt and lived with for the rest of his life back in the United Kingdom. Academic support for the claimant's submissions. I just invite the court to these. They are the Bergson article in the Law Quarterly Review, tab 10, bundle 10, tab 106, MS number 3512. There's a critique of the Court of Appeal decision. Dickinson, volume 10, tab 115, MS 3588. It's really at 3591 and page 215, where he states there's no alignment between Rome 2 and Brussels, even after the decision in Lazare.
So this is also the LQR?
Yeah. Also the LQR, correct, Milady. Then there are the two Briggs articles, which I've already referred to before, at tab 108 of volume 10, 109 of volume 10, which is a commentary on Abella, and basically his thesis is that there should be a downgrading of the test, not the standard of proof, I just call it the test for jurisdictional gateway. He deals with that there as well. And finally, his book, Professor Biggs' book, which is in volume 10, tab 110. And he supports the first instance decisions at his paragraph 4.73, which appears on MS pages 3547 to 8. So our submission is really one can get into philosophical and legal gymnastics when seeking to distinguish between direct and indirect damage. However, with a broadly defined gateway and an additional forum convenience test, the courts can cut through all these difficulties, and the cases of Booth and Wink are testament to that. So the authorities referred to by the defendant, bottom of page 9, Metal is dealing with the question of whether all the damage has been sustained within the jurisdiction. We say that type of approach when the court says some substantial damage sustained within the jurisdiction is sufficient, is at odds with the approach advocated by the defendant. The ERAS actions, as the court knows, it's a very complex dispute. What we submitted does not confront as the issue of direct or consequential loss in our field, the personal injury and fatal accidents type case. Bastone is a short first instance judgment in which the EU approach was adopted in respect of a claim in tort. However, we invite the court to note that that judge had already held jurisdiction was established in England with respect to the claimant's claims in contract. That may have had a reason for dealing with this issue, the tort issue, quite shortly. ABCI, again, a commercial context, conspiracy to defraud. We accept the defendant's correct to say the Court of Appeal treated the tort gateway as consistent with the EU rules on jurisdiction, but it also stated in our judgment damage sustained within the jurisdiction is looking to the direct damage sounding in monetary terms, which the wrongful act produced upon the claimant. That would help us. However, ABCI might be regarded as a case where the Court of Appeal was not persuaded there was any financial loss sustained within the jurisdiction, whether direct or indirect. See the passage of Lord Justice Mance as he then was, his passage there. NewSat, over the page, is a first instance case where the claimant's alternative case on damage sustained within the jurisdiction was not pursued with much vigour, and I can take the matter shortly. Mr. Justice Steele. Erster Group is the Court of Appeal obiter dictum, which we would respectfully set this particular hair running that's now before this court. It's an obiter dictum, Lord Justice Gloucester. It wasn't relevant to their decision. They didn't go any further than say that they had doubts. They didn't give any reasons for the doubts that they expressed. And it's worth noting, as we say there, Mr. Justice Flo, who was the first instance judge and dealt with the case at first instance, made trenchant observations about the jurisdictional gateway, which we've set out there at the bottom of page 11 and the top of page 12. Basically, he said the submission that the defendants now are seeking to advance was unarguable. Relevance of Rome 2. What we seek to say, if I go to paragraph 17 very quickly, because I'm running out of time, the wording of Article 141 in Rome 2 is different from Article 5.3 in Brussels. The EU courts have not taken a consistent view that they should be construed identically. The decision in Keynes sets that out. It's discussed at some length by Professor Briggs in his articles, so I don't need to dwell on it. The case of Lazare as well, as you can see, the very bottom of the page, although the objectives pursued by each of those legal acts are somewhat different, the concepts must, as far as possible, be understood by reference to the interpretations adopted in connection with Brussels or the Brussels regulation. A degree of parallelism must be established in the interpretation of those notions, insofar as legal instruments all pursue an objective of the foreseeability of solutions adopted. The Court did not expressly replicate this passage of the Advocate General's opinion, and the Court does not, as Professor Dickens has observed, base its conclusions on a reading across from the Brussels I regulation to the Rome II regulation. And those are set out at paragraph 18. Basically what they're saying, each of these regulations serves its own purposes, has different objectives, and so fall to be interpreted without recourse to the learning of the other regulation. I must leave time for my learned friend. I've used up mine. 15 minutes for my learned friend, Mr. Chapman, to deal with the remaining points on Fatal Accidents Act.
Given the time available, I propose to be very brief, and rather than
Brief is
taking...
often best.
Well, indeed. And rather than taking the Court to all of the material that's cited in the written case, and indeed now in the speaking note as well, I propose to make submissions rather than taking Lady and Lords through all of that material. It's all set out with page references. I hope can be followed through the written materials rather than necessarily by turning it up over the next 10 minutes or so. The point that I'm going to address the Court on is the issue that was identified by Ms. Kinsler QC at the conclusion of the first day of this appeal, which was whether the claimant can discharge the burden of proving a reasonable prospect of success on the fatal accident claim. This obviously falls to be considered on the assumption that the claim has passed through the jurisdictional gateway, whether in tort or contract, and also that England is a convenient forum, which is not an issue in this appeal in any event. And the question then is whether it has a reasonable prospect. And we've already been to Sequensar, so we know what the standard of proof is in relation to the merits test. It is whether there is a serious issue to be tried. That's Lord Gough. The citation is in the speaking note. And that test, I won't try and reformulate it or put it in a variety of different forms of words, but that test bears something in common, the standard of proof, with the test for summary judgment under the CPR, which is whether there's a real or more than merely fanciful prospect of success in relation to that issue, being the merits. And the defendant's submissions in this regard commenced and concluded essentially with three propositions. The first was that the applicable law of the tort, and in answer to a question which Lord Wilson posed, the contract as well, was not English law. And it followed from that, so it was submitted by the defendant, that there could be no reliance on the Fatal Accidents Act, 1976. Second point for the defendant was that the claim in this case was pleaded only on the basis of the Fatal Accidents Act, and that stood in the way of the claim going over the hurdle of the merits. The third point was that the claimant could not, in this context, rely on any potentially applicable foreign law because such foreign law was not pleaded, the pleading point, and also because there was no evidence before the court of any foreign law in that regard. And by extension of this, perhaps point 4, though it was not addressed in that way, there's no presumption of evidence as to foreign law that could assist the claimant in that regard. And I propose to answer those points insofar as I'm able to in 4 short bullet points, but I'll start, if I may, with 2 preliminary observations that I think will save time. The first preliminary observation is this, that we accept for the claimant that the Cox and Ergo case is authority for the proposition that where a foreign law, in that case German law, is to be applied, then the claimant cannot rely on the Fatal Accidents Act 1976 on the quantification of damage, which was an issue in that case, the effect or the prospect of remarriage might have on the award to the dependents. And in any event, it's also authority in Cox that apart from the application of a foreign law, the 1976 Act does not have extraterritorial effect. That's the first point that we make. We also accept that in Lazare, which is a decision of the Court of Justice of the European Union, decided in the period since the Court of Appeal decision in this appeal, that for the purposes of identifying the damage under Article 4.1 of the Rome II regulation, a point on which you've just been addressed by my learned friend, you look to the injuries which resulted in the death of the deceased to set the applicable law, rather than the later subsequent financial consequences of the same. And therefore, for the purposes of setting the applicable law in a road traffic accident context, a fatal context, the location of the accident determines the applicable law. So I come to my points in relation to the defendant's submissions. And I ask you to also consider these against the backdrop of perhaps two broader matters of principle that arise in this context. The first is this. At what stage in the proceedings is it necessary or desirable for the court to resolve any disputed issues as to which law to apply and as to the content of that law? And is it necessary or desirable that those matters, which may involve some complexity and perhaps foreign law expert evidence, should be resolved at the jurisdictional contest stage? I mean, the obvious answer that we give to that consideration is that it's not necessary or desirable to deal with that at the point of jurisdiction. The second point is this, that if an issue of applicable law and its content is properly raised by the defendant in the context of a jurisdictional challenge, where should the evidential burden lie in that regard? That obviously begs the question whether that applicable law issue, the content of that applicable law issue, has been properly raised. So I come to my 4 points and start with the applicable law issue. It's the claimant's submissions I've already indicated that it's neither necessary nor desirable for the court to resolve at this stage of the litigation the issue as to which law to apply or as to the content of the same, and in particular whether the applicable law, whatever it may be, permits a claim for damages arising out of a wrongful death. And the authority I cite in support of that proposition is the VTB case, where the point was made by Lord Newburger in the course of his judgment, counselled against a detailed, lengthy and expensive interlocutory process to jurisdiction and to the resolution of applicable law issues and the content of what the applicable law might be in a fatal accident context. And yet we say that if applicable law is to be treated as a live issue at the jurisdictional contest stage, there is likely to be an expensive, detailed and lengthy consideration of these matters.
On the facts of this case, how could the law governing the tort be anything other than Egyptian law?
I accept that this is a case that is subject to the Rome II regulation. It is a case where the Rome II regulation would direct, in the context of a claim brought against a Canadian defendant, that you start with the place where the harmful event occurred, and that is, or where the damages were sustained, and that, of course, in the context of the harmful event, is Egypt. So Article 4.1, a straightforward application of Article 4.1 in the context of this case, would direct attention to Egypt.
Yes.
I think we have to make that point, and we do. But that does not, in my submission, rob the point I'm making of validity as to how the court ought best to approach these issues and the content of what the applicable law might be in the context of this jurisdictional contest. What normally happens in personal injury litigation of this sort, whether it be a fatal claim or a conventional personal injury claim, is that, and where the breach of duty is a conventional fault-based duty, which is what we're looking at here, whether you look at the case in contract or whether you look at it in tort, is that the case is pleaded along fairly conventional English lines. A breach of a duty to exercise reasonable care and skill resulting in death, loss, damage, and so forth. What normally happens is that if the defendant takes a point of applicable law or raises a point as to the content of that applicable law, then that matter, having been raised properly in the defence and the claimant having been put on notice, is then dealt with by a preliminary issue trial, with a trial directed to what the applicable law might be, and once determined what its content
It's totally unrealistic in the present case. The problem here is not what is the content of Egyptian law. The problem is that you're relying on the Fatal Accidents Act, which, whatever else one might say about it, is not part of Egyptian law.
No, we accept that. But what we do say in this case is that if you look at the pleading and you score out the references to the Fatal Accidents Act, the claim is pleaded in contract and in tort in respect of a wrongful death. It makes perfect sense, this pleading, even without the references, which are in one paragraph of the particulars of claim and in the prayer. It makes perfect sense in negligence and in breach of contract.
I mean, the Fatal Accidents Act is designed to deal with a peculiarity of English law, that dependents have no claim in tort in their own right, a proposition which, so far as I'm aware, isn't accepted by a single civilized country. I very much doubt whether it's part of the law of Egypt.
That may well be right. What we haven't done is carry out a survey of other countries and other jurisdictions, whether civilized or otherwise, to find out whether they have an equivalent to the Fatal Accidents Act. Such research as
They might not need it.
Well,
Exactly.
they may indeed
The
need
norm
it.
is that the dependents, of course, have their own
Yes.
claim in their own right.
Yes.
And there is this anomaly of English law,
Yes.
which is the sole reason why the Fatal Accidents Act exists.
Indeed. Well, that's right. And indeed, such research as we have carried out in Egypt and Canada, being the other two candidates for the applicable law in this case, as held by the judge at High Court level, that they do have equivalence of a cause of action for dependents in the context of a wrongful death, and that's unsurprising. In fact, in this country, we have, it's referred to in a Law Commission report on wrongful death, and it's been in Halsbury's Laws of England for a very long time. We have, quite independently of the Fatal Accidents Act, a cause of action in contract for the dependents in respect of an unlawful death. The food poisoning case, Jackson and Watson, which is in the bundle and it's in our speaking note as well, is authority for that proposition. To come back to the proper approach which we invite the court to adopt at this stage, which is the stage of jurisdictional contest, we say that the question to ask is there a claim in the nature of a tort or a breach of contract for a wrongful death which has resulted in loss and damage, for which there is a serious and more than merely fanciful issue to be tried, the lower standard of proof? And the answer to that can only be yes, we submit, on any sensible approach to this issue. We say that the same issue, be it in the context of the tort gateway, the consideration as to whether a claim has been made in tort to pass through the CPR provision, has been confronted both in case law, which is set out in the speaking note at paragraph 25. I don't give you the citations now, they're there. And also by Professor Briggs, who we've cited in a variety of contexts in the course of this appeal. But again, he also considers that issue and the extent to which the court only needs something fairly general, a claim made in the nature of a tort, in order for the claim to pass through the tort gateway, and we would say to pass through the merits test as well. So far as the pleading point is concerned, which was my third point, and I deal with this very briefly because I've dealt with to some extent already in answer to the rule of assumptions question. This case is pleaded along conventional English lines, but you can score out those two very brief references to the Fatal Accidents Act, and this claim makes perfect sense in negligence and in contract. And those references in the pleading are certainly, in my submission, not fatal to the application of the merits test here. Can we I'd make a further short point, if I may, in relation to the pleading. We've seen, we make the point in the course of the speaking note that the defendant does not raise any issue in relation to the personal injury claim in this context. There is no Egyptian or Canadian law as to a claim available to someone who is negligently injured by someone either. So the same considerations, we would say, apply in relation to the personal injury claim as they may in relation to the fatal claim. But we do say that the court is entitled to consider when the defendant first put the claimant on notice that there was any challenges to applicable law. I mean, very often in these matters, defendants choose not to take a point as to applicable law or as to the content of the applicable law. And in this case, the witness statements that were served in support of the application to contest jurisdiction raised no point as to the applicable law, as to the content, or as to the content of the same. It was only in my learned friend's skeleton argument exchanged the day before the hearing in front of Master Cook that any issue was taken as to applicable law. Finally, the presumption as to foreign law. We say, contrary to the submissions you heard back in May, that there is a role for the presumption as to foreign law, as the Court of Appeal held and as Mr. Justice Tuggan held in this case. Absent evidence of what was described by the Court of Appeal as a startling proposition, that there was no cause of action available in respect of available to the dependents in respect to the fatal claim, the court is, we say, entitled to proceed on the basis that there are no material differences between English law and any conceivably relevant foreign law. There's nothing particularly exotic or surprising or difficult about the notion, the basic notion, that if by your negligence you cause someone to suffer personal injury or you cause a fatality, that a cause of action survives to the dependents. That is exactly the sort of matter, in my submission, of which the court is entitled to apply the presumption and to find that there are no material differences. So far as the case of Belhage and Straw is concerned, which I believe was a matter that the first instance decision by Mr. Justice Simon, on which fairly heavy reliance was placed at the conclusion of Ms. Kinsler's submissions, we just say this: that was a complex matter that arose out of the alleged unlawful abduction and kidnapping and illegal removal across a variety of state boundaries, and ultimately, I think, to Libya, of a number of foreign nationals. And there were issues in that case about the extent and application of state immunity in the Act of State doctrines, which do not obviously arise in this case. The issue before Mr. Justice Simon was whether part of the claim should be struck out, in particular the claims for unlawful abduction, kidnapping and illegal removal. It wasn't a jurisdictional contest. The issue arose, that is the foreign law issue in that case, arose at a preliminary issue trial, and after particulars of claim, defences and a reply had been served, the claimants were put on notice that foreign law and the content of the same were very much in issue. And the Court of Appeal emphasised, when the matter came before it on appeal, that the issue arose after service, that is the foreign law issue arose after service of a fully pleaded defence and disclosure, and indicated clearly that there was an exception to the general presumptions of foreign law being the same, where, quote, as here, the issue of the applicable law is plainly engaged on the pleadings and on the facts, and the court is in a position to adjudicate on the point. That was not the position we submit before Master Cook for the reasons I've already given. The unlawful detention and false imprisonment and conspiracy claims in that case were struck out. But the same factual circumstances were also relied on by the claimants in that case to give rise to a claim in negligence. And that claim in negligence was not struck out. That proceeded. Did not form part of the preliminary determination. And we say, similarly, we do in the speaking note, that there's nothing fictional or artificial or unrealistic, or to use the word I used earlier, exotic, about the contention that a breach of duty, which gives rise to an unlawful death, whether a breach of duty in contract or in tort, gives rise to a cause of action. And that, we say, is sufficient, clearly sufficient for us to pass the merits test. Those are our submissions in that regard.
Thank you very much, Mr. Chairman. Thank you.
Can you move?
Please, Your Ladyship, deal with a number of points. Firstly, the correct defendant. Our submission is that the claimant does not have and never had a good arguable case in terms of the Canada Trust gloss that the other contracting party to her conversation with the concierge was Four Seasons Holdings Incorporated, or Inc. We say that regardless of the new evidence, the claimant never had such a case. She sued the holding company, which she accepted was at the top of a group of companies. She'd never heard of the holding company, FSHI, as an entity, as far as we know, and certainly not at the time of the contract. Your lordships and ladyship will recall that there was confusion at the date of issue as to what the title of the selected defendant actually was. We dealt with that in our written case at paragraph 26. We accept that the evidence put in by the defendant was minimal and we accept was poorly prepared, and it has been described in uncomplimentary terms in this court, but it couldn't possibly have been read as supporting the contention that the holding company was the other contracting party or the operator of the hotel. Mr. Justice.
Well, one of the statements said that the holding company was a manager.
It was involved in management.
Yes.
Miss Henderson's statement that she put in accepted that it has a managing role of companies, but not that it is a manager of hotels. And there was nothing in my submission that supports the suggestion that it was, as it were, a manager of individual hotels in the Four Seasons stable. Now, I accept that it was not unambiguous, but it wasn't sufficient, in my respectful submission, to suggest that it was being accepted that it was managing any particular hotel or hotels at all. It merely had a function, as Ms. Henderson explains, of keeping an eye on how the group of companies made its money and was successful throughout the world. So, my Lord, Mr. Justice Tugendhat, in our respectful submission, went far too far in going from a first fiercely critical stance, which I should say originally he suggested that the deponents had deliberately contravened the rules about preparing their evidence. And we have put in before the court a bundle of documents which includes his draft judgment, which was responded to by the solicitors requesting to make clear that their inefficiency was inadvertent, which they did. And Mr. Justice Tugendhat did amend his judgment, but he only amended 2 paragraphs, which were the specific ones where deliberate mispreparation was suggested, and the critical nature of his judgment still does shine through. But we submit that on a cold and logical analysis of the evidence, there simply wasn't sufficient evidence to support the mere suggestion, effectively, by the claimant that she had entered into a contract with this holding company in Canada. And the new evidence, if I may be so bold as to remind the court, was brought because, not surprisingly, this court wanted to know what our positive case was, which we had been reticent about. And Lord Sumption pointed out that not only did the claimant potentially suffer the risk, as he put it, of hitting the buffers at a later date if assumptions were made which weren't justified, and which would then come out once the case began to be disputed on the merits. And I think Lord Sumption also threatened an order for disclosure to compel the answer. So the instructions were taken and put before the court, and Lord Sumption also said that it might enable the court to form a view whether Mr. Justice Tugendhat was right to attribute unattractive motives to the clients. And in my respectful submission, the evidence that's been put in shows that that would not be right, and that the most that can be said against my client was that they were playing their cards extremely close to their chest, and doing so in circumstances which were unhelpful to the claimant.
But there is perhaps one moral from this whole saga, is there not? That whenever you book a foreign holiday with anybody, be they so enormous and prestigious as Four Seasons or something much more limited and humble, make sure you know who you're making your contract with.
Well, I would accept that, and it's true, in fact, when one goes into a Pizza Express and orders a pizza. But I'm afraid that is a feature of modern life, is that one doesn't always do that.
I wonder whether the concierge at the Nile Plaza Hotel
would have known.
would have been ready with the kind of answers that we've got in Miss Henderson's affidavit.
Well, of course, yes. But she probably knew who her contract of employment was with.
I'm sure.
Yes.
If, of course, Egyptian law is anything like English law on that topic.
On that topic. Clearly, now the evidence has put in, and it was sought by my learned friend. We answered the question on instructions as to who we said the parties were and how the company was constructed. And both he and the court requested or required evidence to be put in to support that. So we contend that the evidence is there, and one way or another it is quite clear and requires no further session of any court that the claim against this particular defendant, the FSH Inc., it should be struck out as not being a case against the correct defendant. But as I say, we also submit that even without that evidence, there was not a sufficient case that the holding company was the other contracting party. Of course, I have sympathy for the claimant in not knowing the company structure, but I would point out that she had Nova Park SAE as a defendant, which is in fact the correct defendant for what she wants. She could have applied for disclosure. There are procedures for doing so. She could have sued in Canada, in which case no jurisdictional question would have arisen, and she would not have had the problems created by a jurisdictional contest in this country. And finally, I would say that the defendant is not and was not, other than by order obtained, legally obliged to do more than to deny the contention that was being made against them.
Are we bound to strike it out? Suppose that we are satisfied that the first defendant was not a party to the contract. An alternative, of course, would be for us simply to make a declaration to that effect, thus leaving the action in being so that it can go back to the High Court with a view to the addition, or, if Mr. Chapman is right, substitution of other parties who are liable or potentially so.
Well, my Lord, I would submit that striking out the claim against FSHI follows, as night follows day, the declaration that there is no jurisdiction that this court has to entertain a claim against FSHI. It is a peculiarity of this particular claim form that it does still exist in presenting a claim against Nova Park SAE.
Well, the writ's expired.
Well, nowadays, of course, the old days of the writ actually expiring its validity have gone. The question is whether you're allowed to serve the writ or not. Now, I accept that the contention that they could serve so long after the date when the writ was issued would be a pretty hopeless one. I mean, I would say it would be a hopeless one.
Well, would it? I mean, in this case, they didn't actually, although they had joined Nova Park, having discovered that they were, I think, the owners of the site, they didn't actually know about the role of Nova Park in the contractual web until they saw Miss Henderson's witness statement. So
they knew enough to prepare a claim form which contended that Nova Park was liable for the accident which had occurred in the alternative to FSHI. So it was a claim form which was valid at the time, and the claimant unaccountably didn't seek to proceed against Nova Park SAE. But, my Lord, in answer to your question, I would submit that the claim against FSHI should be struck out. Whether the claimant can do anything with her claim against Nova Park SAE is a moot point and would not be affected by the strikeout. I would submit that, in fact, substitution is simply not available against Four Seasons Nova Park Cairo LLC because, as your Lordship, I think, pointed out, the claim was directed at the holding company as the holding company and the head of the group. Service was effected on it, and the company which the claimant now seeks or may wish to put in the frame is a separate corporate entity which is in Egypt. It wasn't.
That's the LLC company.
The LLC company, yes, Four Seasons.
I mean, they're the people who ought to have been sued, are they?
They are the other, well, if your Lordship recalls, the LLC company operated and managed the hotel as agent for Nova Park Cairo SAE. So technically, the proper target is the hotel because they are the principal, but clearly in the case of an agent who's operating the hotel for and on behalf of, there would be a good arguable case that that company would be liable even though it was acting as agent for the principal.
I mean, all this will have to be sorted out at some future trial.
Well, or at some future, if we sought to join that company in this country, at some future jurisdiction application there. But that could be done, and the evidence which Lady Brownlie has put in suggests, although I don't endorse the suggestion necessarily, but that is her case, that she can start again against the LLC by issuing fresh proceedings because she has time from the date of discovery of the identity of the LLC. So there's no real need for her to go down a more complicated route than simply issuing proceedings against the LLC and seeking to argue that point of limitation if it arises. But remitting the case in some way would not in any way assist her because, as I say, substitution would not be possible and adding a further defendant is no different effectively from issuing fresh proceedings and proceeding on those on that new action. My Lord Sumption is concerned that on the question of the place of contract, there will be some sort of issue estoppel against a future different defendant. My respectful submission to that...
No, not against the future different defendant,
Sorry?
only against the present parties.
Yes, well, the
I
present party.
I wasn't suggesting there could possibly be an issue estoppel against a non-party.
No. So there is no reason why your lordships and ladyship shouldn't decide that issue in the context of this application and decide that, quite apart from the question of who the contracting party was, that the claimant has failed to make out a case that the contract was made in England. And that is the end of her contractual claim against FSHI, regardless of whether it's the correct defendant or not. So I would invite your lordships certainly to conclude that issue, which has nothing to do with the question whether FSHI should have adduced more evidence about the background to its company's operations around the world. Lord, may I get on to the question of where the contract was made and the Canada Trust gloss. As far as the gloss is concerned, our submissions are that Second SAR does set a high hurdle for satisfying the gateway, which is considerably more onerous than the standard of demonstrating a case on the merits, and I dealt with that in opening. The court must be satisfied that the conditions exist through the gateways that give the court the power to take jurisdiction over a foreigner. The test is laid down in Canada Trust. It's been accepted. It was accepted, admittedly, without any argument in the House of Lords in that case by Lord Steyn, and it was accepted by the Privy Council in the case of Bolse, which is at tab 13 of volume 2, MS 998. And yes, tab 13, page 998. And it was expressly approved by Lord Collins as the correct approach in the case of Altino, which was another Privy Council decision, which is at Authorities Bundle 1, tab 4, MS 78, at paragraph 71. That is the test. The claimant's written case at paragraph 65A in her conclusion said that the Canada Trust gloss was accepted, albeit without the word much the better argument. And your lordships discussed the word much with me in opening, and I accepted that the word much is not particularly helpful, save to demonstrate that it must be satisfied so as to adopt these gateways, one of these gateways. So when one looks at this particular issue, the burden is on the claimant to establish the connecting factor with regard to the contract by adducing evidence and argument. And in this case, the evidence simply didn't address the relevant issue, the issue being where was acceptance received. And the gloss, I would respectfully submit, requires the court not to go down a route of trying to find an answer on the balance of probabilities, but to look at the evidence and argument which is put forward to support a particular contention. And you have to look at the contention. What you're not allowed to do, because it comes close to the balance of probabilities system, is to speculate what would happen, as Mr. Justice Tugendhat did, and say, well, this might have happened, and I infer that might have happened, and therefore I can arrive at a situation in which the concierge had the last word and said, I accept your offer, Lady Brownlie. That just simply is not applying the requisite test. This is a case where the connecting factor is one which depends upon a very precise and very small detail of a conversation. And in my submission, if the claimant cannot precisely demonstrate that the feature, namely the last word, occurred in this particular case in the correct way, namely an acceptance directed to England, then she cannot achieve the task of satisfying the court that there is a ground for jurisdiction. The case of Kenwright, you may recall, was where Mr. Kenwright, I think it was, had sent a letter with his terms offered to the other side. The other side had rung up and said, I accept those terms. And that was noted in Mr. Kenwright's daybook. And there was nothing to say anything to the contrary. But that is completely different from the situation that we have here. And it's quite clear when one looks at the evidence that when it was prepared, the claimant was not aware of the importance of this connecting factor and considered that merely saying that the contract had been made while she was on the telephone was going to be sufficient. And it is quite wrong in our respectful submission that the court should have speculated in any way to try and create a scenario in which Lady Brownlie was the one who received the final confirmation. And as Lord Sumption said, the burden is upon her. The price is surely crucial to any contract which is arranged, and Lady Brownlie's evidence simply doesn't address that question. The learned friend said, oh, well, she might have done it in October when she was told it was too early to book a tour. But, I mean, that is just more speculation. And we respectfully submit that it cannot be the case on the evidence produced in this case that there was a contract made in England. And the decision is effectively tantamount to saying that if an agreement is made by a telephone conversation when one party is in the UK, that is sufficient to create a connecting factor, because no one will ever know precisely how the conversation went, and it'll be possible for a reconstruction to postulate one or the other outcome, in which case the way my learned friend puts the case effectively is that that's sufficient to create the necessary connecting factor. And when my friend, and indeed Mr. Justice Tugendhat, refers to factors existing, that factors exist that satisfy the necessary connecting factor or satisfy the ability of the court to accept jurisdiction, what that means is that there must be clear satisfaction that the terms of a particular gateway have been satisfied. And it's not good enough simply to say, well, as a matter of sympathy for Lady Brownlie, there is sufficient of a factor when that issue has not been addressed. Turning then to the question of damage sustained, your Lordship and Ladyship have had my submissions on that, and there's really very little new that my friend has put forward. There are, of course, these numerous first instance decisions, but they all go against the decisions of the Court of Appeal that the European test is the correct one. Professor Briggs is running, if I may suggest, a bit of a campaign, which is, with respect to him, directed at suggesting that really the predominant interest of the court should be whether the issue of forum non-conveniens can be decided in favour of a claimant, and more or less to ignore the necessity for the jurisdictional gateways. But that is simply wrong. There is House of Lords authority in the Siskina, and I would refer the House to Lord Diplock at Bundle 7, tab 67, at MS 2574, and Lord Helsham in that case at MS 2618, which demonstrate clearly that it is a requirement and a requirement of some strictness that the gateways are to be properly satisfied. And that, of course, is where the second SAR analysis starts from and where the Canada Trust gloss gets to. So those gateways...
What was the first reference that you gave us?
Was Lord Diplock at MS 2574.
That's the first page of the report.
Oh, I'm sorry, then that isn't the one I intended. I think it is actually...
It is the case, but it's not...
It is at MS 2618.
Right, and then you referred also
Then I
to Lord
referred
Helsham.
to Lord Hailsham. 7. Lord Hailsham was at 2626, page 262 of the report, reminding the court that the jurisdiction of the Rules Committee is statutory and it's not for the judges to preempt the functions of that committee or to go outside the rules of what is effectively legislation. So it is a strict requirement, and we submit that it is bad law and bad principle to argue, as my friend does with support from Professor Briggs, that the first instance judges, such as Mr. Justice Tugendhat, can widen the gateway because they are able to control the number of claims by reference to the concept of forum non-conveniens. That is simply incorrect. In law, as I've said, from the Siskina and many other cases. And indeed, it's also bad in principle because the two controlling mechanisms are in fact serving different functions. The requirement to comply with the gateway is a requirement to demonstrate that there is a connection between the defendant or his conduct and this country. So if he's made a contract in this country, then there is a connection between his conduct and this country. The question of, and that is why the gateways are there, to create that or demonstrate that connection, and it must be distinctly demonstrated. To demonstrate that a trial here will be appropriate or fair or convenient does not address that issue. It takes into account the interests of both parties. It takes into account all sorts of elements, such as how convenient it would be to have the evidence heard by a trial here as opposed to somewhere else. And finally, it is a decision which is left to the wide discretion of the judge. So to suggest that you can some way supplant the necessity for satisfying the gateway by effectively ignoring it and just dealing with forum non-conveniens is extremely unconvincing. And my learned friend suggested that the amendments to the CPR in 1983 and 1987 were made before the Bier principle had been shown to be limited to direct damage and not to allow for consequential loss. But that's simply not so, because it was accepted after the Advocate General's opinion in Ruffer which is at Bundle 10, tab 103, MS 3473, at MS 3486.
Hang on.
Which is page
3486.
3486 MS number, 3836 report number. In 1980, it was clearly stated that the damage had to be direct damage and not consequential loss arising from that direct damage. And it was also expressly accepted in the Court of Appeal in the Eras Isle actions by Lord Justice Mustill, and that's at Bundle 7, tab 68. I'm not sure I have the MS number, but it's page 591 of the report. I think it's MS 2649. So it's all very well to go down the route of looking at all those first instance decisions and say they're consistent with one another, but they are inconsistent with a line of Court of Appeal authorities, such as the Eras Isle action, and indeed Metal and Rostoff, which explain that this rule was a rule which used to say the whole tort must occur in this country, and it was widened to say not the whole tort, but the damage coming from the tort must occur in this country, and that arose out of the Article 5.3 jurisprudence, and it was limited to, and everyone knew it was limited to, the direct damage caused by the tortious activity. My Lord, I will therefore give way to my learned junior to deal with the question of the Fatal Accidents Act and the question of establishing the merits.
My Lady, another brief foray onto this issue. Can the claimant establish reasonable prospects of success with respect to the fatal claim? And in our submission on the pleadings and evidence, she cannot do so. I think it's important to remember the purpose of the merits part of the jurisdiction test. It's to ensure that a foreign defendant is not brought before the English courts to answer claims which do not have reasonable prospects of success. And the court's consideration of jurisdiction provides an opportunity to stop unmeritorious claims proceeding at an early stage. And that purpose will be defeated unless the court considers the merits on a realistic and a true basis. And in my submission, that has to be done by reference both to the legal framework and the pleaded claim. And the claimant's case requires the court to disregard both those elements and to proceed on an unrealistic and an artificial basis. And in my submission, on an application for permission to serve out, where the claimant is inviting the court to exercise a discretion, that is not an appropriate way to proceed. As far as the legal framework is concerned, there's two elements in this case. There's the applicable law, and there's the issue of the Fatal Accidents Act. In any case with an international element, obviously the issue of applicable law is critical to assessing merits. The claimant says, well, it's unnecessary to determine it and it's premature. Far from being unnecessary, in my submission, it is truly essential, because otherwise the court is being invited to assess the merits on a wholly artificial basis, by reference to a fiction which will not pertain at trial. The claimant says all she has to show is reasonable prospects of success. That's in her written case. But you can't assess merits in a legal vacuum. You need to know which law applies and which elements need to be satisfied. And whilst we acknowledge, of course, that in certain cases it may be premature to take a decision about the applicable law, in very complex cases where it's highly fact-sensitive, it could well be premature. But this is not one of those cases. In this case, it is clear, and indeed the contrary is not argued, that the applicable law is not English law. It is Egyptian law. And I refer the court to two decisions of the Court of Appeal relatively recently, Belhaj and Erste Bank. In both those cases, the Court of Appeal said it was not premature to determine the applicable law at an early stage in the proceedings. So we know it's Egyptian law. It would be different in my submission if it was arguably English law. There might be much more scope for the claimant's arguments, but in this case it's not arguable. We know, and it's now common ground, that the Fatal Accidents Act does not apply in this case and cannot apply, because this court has ruled that in a case where the English law is not the applicable law, the Fatal Accidents Act has no application. There was a suggestion in the claimant's written case that there might be some scope still for relying on it, but that has now clearly been quite properly abandoned. So that's the legal framework, the applicable law and the Fatal Accidents Act. And now if we think about the pleaded claim, I took the court to the various parts of the pleaded claim on the last occasion. And it's important to remember, obviously, that each claim must pass the merits test. So each claim, both in contract and in tort, has to be looked at separately between each pair of parties. And the claimant in this case has three different hats, and it's the fatal claim that we're talking about against the defendant. The claimant says the pleading doesn't matter. It's pleaded on a conventional basis, as it would be in an English court, and it makes reference to UK statutes that would apply. Well, what does that mean? They would only apply if English law applies. They refer to the fact that the pleaded claims, they're not confined by their pleaded claims to damages that might be awarded in England under such statutes. And the references to those statutes are not averments which are essential to the causes of action. I think the suggestion must be that at a later stage, the claimant will be amending their claim to plead foreign causes of action. And in my submission, the claimant's approach in this regard is fundamentally flawed. It disregards the long-established treatment by the English courts of foreign law as a matter of fact, which must be pleaded and which must be proved. And your Ladyship and your Lordship may recall that on the last occasion I took you at some length to the extract from Dicey on that point, and I don't think that's an issue. Not only does it disregard that, but it devalues entirely the role of pleading. Pleadings are intended to define and circumscribe the causes of action the defendant has to meet. And that's particularly important in my submission in the context of a jurisdiction application. The court is inviting this court to exercise jurisdiction against a specific defendant, I don't know which one at the moment, but in relation to specific pleaded claims. And it's unreal and artificial simply to say, well, it doesn't really matter what the pleading says. We've pleaded facts, and we might have a cause of action in foreign law. I referred the court at the end of my submissions last time to the Court of Appeal's decision in Belhaj, and I do invite the court to look at that, not at the moment because of time. It's in Volume 2, Tab 9 at MS 881, and in that case, the Court of Appeal upholds Mr. Justice Simon's decision that, not in a jurisdiction context, but at an early stage in the proceedings, when it is not arguable that English law applies, it is unreal and artificial to allow the claimant to proceed on the basis.
Have you got a paragraph reference for that?
Certainly. So the case starts at MS 881. The relevant passage starts at paragraph 149, so MS 940. We turn next to the issue of pleading of foreign law and the presumption.
I just want the reference.
Yes.
I'll look at
And it goes down to paragraph 158, MS 942. I suppose it's equally valid in the jurisdiction context. I should draw your Ladyship and Lordship's attention to the Court of Appeal decision in Erste Bank. I had expected my learned friend to refer to it, but that was a recent decision looking at the pleading question in the jurisdiction context. But in that case, there was a lot of evidence of the foreign law, voluminous evidence of Russian law, and the Court of Appeal held in that case it was appropriate, or it was satisfactory that the claimants had relied on English law. The only other point I make about that case briefly is that it relies on another decision, Kuwait Oil, which Lordships may recall was taken in the context of the double actionability rule. And that's obviously an entirely different legal framework from we're in at the moment. So Rome II mandates certain choice of law rules. The cause of action is a foreign cause of action in this case. It's not the same as under double actionability. You had to make sure it was actionable under foreign law, but your cause of action was an English cause of action. So it is a very different legal framework in my submission. My learned friends rely on the presumption. As I said on the last occasion, it is important to think about what the court's doing, and a better phrase is a default rule. The reality is that in the absence of proof, the English court applies English law in the absence of proof of foreign law. And that doesn't assist the claimant in this case, because the Fatal Accidents Act doesn't apply. So either you need to disregard this court's judgment in Cox, or you disregard the choice of law rules, because otherwise the Fatal Accidents Act simply doesn't apply. My learned friend in the written note handed up today says, well, we're not relying on the Fatal Accidents Act, we'll rely on something else. But the court either has to apply English law or foreign law. There isn't anything in between. And in my submission, to say, well, most countries, if perhaps all countries, will have such a cause of action, really is nowhere to the point. Either the foreign law is applied or the English law is applied. And in the absence of any evidence of foreign law, all we have is English law, and we know it doesn't apply. My second point on this is that it is inappropriate in a case for an application for permission to serve out to rely on such a presumption. It's clear from the case law that there have always been exceptions. On such an application, the claimant bears the burden of proof, bears the burden of coming to this court and satisfying the court that on the merits they have, or she has, a reasonable prospect of success. And to allow the claimant to rely on the presumption would, in my submission, be to defeat the merits test. It would be a wholly artificial exercise to consider the merits by reference to a fiction. English law will not apply and does not apply to this claim. And in the Court of Appeal, Lady Justice Arden said, well, Mr. Palmer hasn't answered the question about what the court should do in the absence of foreign law. Well, in this case, in my submission, it's easy. The claimant comes to the court, says, please can I have permission to serve out for these causes of action? The Fatal Accidents Act doesn't apply. Yes, there's other facts in the pleading, but there's no fact of foreign law. So there is no cause of action that has real prospects of success. So the court's not in any difficulty. The court does what it would do in any other case where the pleading doesn't disclose a reasonable cause of action, that the cause of action comes to an end, or the pleading comes to an end in that respect. And then friend says it's for the defendant to prove that there's a difference. And in my submission, that's simply not correct. That's putting the burden onto the defendant. And the cases show, and it's well established, that the burden is clearly on the claimant on each of these tests. And there's no warrant for imposing such a burden on the defendant. A similar argument was dismissed by the Court of Appeal in the Belhaj case. My Lady, just before I finish, I would just like to say that the extract from Professor Fentman, to which I referred the court on the last occasion, I should just give the date of that. It's the 1st of October 2014, the textbook extract. So it's before the Court of Appeal in Belhaj and Erste Bank and indeed Brownlie. So it just needs to be read in that context because the law is relatively fast-moving in this area. So in conclusion, English law is not applicable. The contrary is not argued. The Fatal Accidents Act does not apply. Again, that's common ground. Foreign law is a matter of fact, and it must be pleaded and proved, and there is no pleading. Reliance on the presumption or default rule does not assist, and in any event is not appropriate. The claimant invites the court to ignore the realities and the legal framework and to exercise jurisdiction on an artificial basis, and I invite the court to decline to do so. Unless I can be of any further assistance, those are my submissions.
Oh, it appears that you can't. Thank you very much indeed.
Lady, I've had my turn. I just wanted to raise this one issue, which relates to what's to happen with the case on the other contracting party, because the way things have developed, we haven't had an opportunity to make any application for substitution. My Lord Clerk postulates, let's go with the thesis at the moment, that there is another party who's clearly responsible. That must be an argument. Which is that other party? Assume for the moment it's LLC. Why, by virtue of the fact that these defendants, midway through an appeal in the Supreme Court reveal documentation which for the first time identifies that it's not the only person who it otherwise could have been on the documentation that's before the court, namely Holdings Inc. We must be, in our respectfulness, afforded some opportunity to make an application for substitution, if that be so. My learned friend says, in answer to this, oh, well, there's a limitation period that may not have expired in Egypt. If he's prepared to concede that that point will not be taken, that'd be a different matter. But I venture to suggest he's going to say to this court, well, he doesn't represent LLC, because that's the sort of point that's been taken against us so far.
Well, even if he were to stand up
Yeah.
and concede the point, he can't. He's not instructed on behalf of LLC. It's not obtuseness.
Well,
on
he
his part.
may have instructions from LLC, given the closeness between these companies, for all I know. But Your Lordship would be right if he's without instructions. So the answer to this is that discrete issue should be sent down for a proper hearing when the parties have had disclosure and know which targets they really should be aiming at.
Well, you
seen no
have made that point several times, Mr. Ross.
Well, I'm sorry if I overemphasise it, but Your Ladyship will understand why I'm concerned on behalf of my client.
Thank you very much, Mr. Ross.
My lady, although I may be deficient in my ability to give the source of my information and belief, I understand that today may be Lord Clerk's last sitting day. If that is correct, it shouldn't pass without there being good wishes from the bar, both here and I'm sure widely around London, and appreciation from us all for Your Lordship's long service in the Admiralty Court, where I appeared on a number of occasions representing a fraudulent cotton broker, and of course your service as the Master of the Rolls in the Court of Appeal before coming to this court. So if I may just express those wishes and appreciation before Your Lordship rises.
That's very kind of you. Thank you very much.
May Your Lordship have an opportunity for more bar golf.
I hope so too. Thank you very much.
There will be formal valedictories on the very last day of Lord Clerk's sitting, which will be a week tomorrow, when no doubt suitable and even more extensive tributes will be paid.
I apologise.
Not only to him, but also to Lord Newburger, whose last day it will also be. But thank you both very much.
Some of us are beginning to think enough is enough.
On that happy note, the court is now adjourned.
Thank you.